Issuing warrants for arrest? No, that didn't happen.
How does sleep apnea or menopause contribute to lying?
Well, it affects her mood. It affects her ability to think clearly. It affected numerous areas of her life.
How did this contribution cause 5 people to spend 28 days in jail?
Okay.
Sorry.
Okay.
Jails.
Okay. Okay. I'm like, stop it. Not everybody watch the news. I'm going to call him and tell him don't come. I'm sure he is. Look, idiot.
There is no question that the conduct engaged in by Judge Pinkey Carr was egregious, and it lasted for a period of approximately 2 years.
Welcome back to Legal Dissent, where we evaluate your constitutional rights before they're taken away. Thank you so much for joining us, and as always, if you enjoy our content, please do help spread our message of government transparency and accountability by liking this video, subscribing to the channel, and interacting with us in the comments below. It really does help us out a lot in the YouTube algorithm. Judge Pinkey Carr was admitted to practice law in Ohio in 1993, and since January of 2012, she's been serving as a judge in the Cleveland Municipal Court. Before that, she had spent 13 years as a prosecuting attorney. Just a few months ago, on December 10th, 2021, the Board of Professional Conduct of the Supreme Court of Ohio, who governs the discipline of attorneys, released a report that levied 5 counts of misconduct against Judge Carr. Count number 1, issuance of capiases and false statements. A capias is essentially an arrest warrant. Count 2, ex parte communications, improper plea bargaining, and arbitrary dispositions. Count 3, improper use of capiases and bond to compel payment of fines and court costs. Count 4, public confidence, a lack of decorum, and dignity consistent with judicial office. And finally, count 5, abuse of contempt of power and failure to recuse. This all started on March 13th, 2020, when the administrative and presiding judge of the Cleveland Municipal Court issued an order suspending courthouse activity to prevent the spread of COVID-19 and required all civil and criminal cases to be rescheduled and postponed to 3 weeks later. Despite this order, Carr refused to reschedule and issued capiases for the criminal defendants who did not show up to her court. That's when the public defender assigned to her courtroom, Mark Jablonski, asked her about what was going on.
Is the court having a docket tomorrow?
Oh, yeah. Nothing stopped for me. My cases go on. Oh, yeah.
Does that apply to jails only?
No. Anyone that shows up. Not everybody watches the news. I actually had people yesterday. I had people today. Yeah, I'm not going to do that to people. Yeah, some people have taken off from work. I'm not doing that to them. I will be here.
Judge, can I ask this? If we are able to get a hold of any of our clients who are scheduled for tomorrow who are not in jail, can we tell them to continue to hit?
No.
So the court's administrative order regarding continues?
I'm here. If people show up, I'm here. So no, don't call people and tell them not to show up. If they show up, I'm here.
In light of this
don't do
pandemic,
that.
there's no concern?
Hi, for the 3rd time.
Okay.
I
Just
will
clarify.
be
Thank you,
here.
Judge.
If people show up, I am here.
Thank you, Judge.
Okay, thank you. Okay.
Sorry.
Okay.
Jails.
Okay. Okay.
After several more okays, Jablonski left the courtroom, and Judge Carr had this to say.
I'm like, stop it. Not everybody watch the news. I'm going to call him and tell him don't come. I'm sure he is. Look, idiot.
Another attorney had similar questions the very next day.
Should we call off our bail clients for Monday?
As I indicated to attorney Mark Jablonski yesterday, if people have taken off from work, I will be here. if people show up, I will be here. If you want to call your clients and tell them not to show up, that is on you. But as I indicated to him yesterday, he doesn't have to tell them not to show up. If the building is open, I will be here. I am more than willing to take care of them. But that's entirely on you.
Okay,
I will be here.
thank you.
While I can respect the decision to continue working and keeping the courtroom open for people who decide to come, it is completely inappropriate to punish individuals for abiding by an administrative order that required their cases to be rescheduled. It was completely unfair and illegal for her to issue warrants for the arrest of people who are not required to be in court. Even a bigger issue is that when asked about why she issued warrants for their arrests, she lied.
Issuing warrants for arrest? No, that didn't happen. If people came to court and they were willing to risk their health, I figured I would return the favor. As far as issuing warrants for their arrest, absolutely untrue.
Very clearly, you can see that she did issue warrants and set bond for those who did not show up to her court, even though they were not required to be there.
I can't believe you people braved it coming down here. Everybody else was scared. We're not scared. I'm so glad we're here.
Scared.
You're scared? Okay,
Yes,
Linda,
I
you
had
stay
to
there.
come
You stay there, Linda.
I had to come in though.
Derez, hearing no response, note the time, 8:55. Officer present, no defendant. KPS will be issued. Thanks, officer. Have a good day. Be safe out there. Good to see you.
Good to see you too.
Let's see. Defendant was KPS on October the 4th. KPS again. Note the time, 8:58. It's a miracle. People are here. You know what that article will do? Now that people have known. Oh, Judge Carr, issue a warrant for your arrest. Is that gonna make people come down here now? Brilliant. Brilliant. I don't even think they thought about that part.
No.
It's like, oh, watch everybody run down here Monday. Oh, because Judge Carr gonna issue a warrant for my arrest.
46 on the
Dum-dums.
docket. Richardson?
Dum-dums. Capias. Bond is set at 10,000. Originally called at 9:07. Note the time, 9:10. Capias. Bond is set at 5,000. You know what? I'll just put a straight Capias on.
Okay.
Yep, just a straight Cape. No bond. Capias bond is set at 5,000. Note the time, 9:14. Then it was Capias on February the 5th, 2020. Capias again, bond is set at $5,000. Then it was Capias on February the 22nd. Capias again, first degree driving under the influence, bond is set at $5,000. Note the time, 8:48 on docket number 5. KPS 8:51. KPS 3 previous occasions. Note the time, 8:53 on docket number 24. KPS bond is set at $2,500. KPS 2 previous occasions. KPS again. Note the time, 8:54. Docket number 31. Bond is set at $2,500.
This deception continued on to an email with Judge Early, where Carr said that with Cleveland.com's inaccurate reporting, she would have even more defendants show up because they would be afraid of having warrants issued for their arrest. Early replied, "You didn't do arrest warrants for people who failed to appear," to which Carr responded, "Too late to ask that ridiculous question," and that her jury entries reflected that no warrant to issue, which is just not true. Count 2 was in regard to ex parte communications, where Carr would routinely conduct hearings without the prosecutor present, and would say things to staff such as, "The prosecutor's not here, let's see how much we can get away with." And, "Well, the prosecutor is not here, so we need to get as many of these done before he or she gets here." She also gave some defendants preferential treatment. For example, one defendant accused of not wearing his seatbelt was asked by Carr how much he thought he should have to pay, to which he replied, "I don't know, ma'am." Her response was, "I'm not a ma'am, little boy, I'm Judge Carr." Once learning that he knew one of the bailiffs, she asked how he knew him. from the bar, from the strip club, from AA, NA, and eventually she waived his fines because he knew the bailiff. However, Carr checked the box that the defendant's fines were waived because he was unable to pay. This is just one example of many where she misrepresented the truth on her journal entries and arbitrarily administered justice based on birthdays and who the defendant knew. The third count was in regard to 6 instances where Carr incarcerated defendants to compel them to pay fines and costs. In her own testimony, she admitted that she had created a modern-day debtor's prison and improperly used capiases as a means to compel the payment of fines. In an explanation to her staff, she stated, quote, "I'm no longer the bill collector for the clerk's office. I'm not your bitch. Collect your own money, player. How you like them apples, suckers," end quote. Count 4 is in regard to the public's confidence in the courtroom that is maintained by decorum and dignity, which is why courtrooms have a certain dress code to emphasize the professionalism of everyone involved. However, Carr would refer to her bailiff in open court as Miss Puddin' and would appear on the bench wearing workout attire, including tank tops and spandex. In addition to this, her bench was covered in dolls, cups, and junk that her own attorney described as resembling a flea market. More concerning, however, was her joking manner in which she seemed willing to accept bribes. In July of 2020, an individual who worked for an automotive company was in court. The conversation they had implied that she would waive his fees in exchange for hooking her up with car repairs being covered by the defendant. The final count details Carr's abuse of contempt of power and her failure to recuse herself in certain cases where she took a disliking to defendants with no cause. However, in oral arguments before the Ohio Supreme Court just a couple of weeks ago, it's her defense to all of these accusations that seems the most bizarre, as she claims that certain health disorders were the major culprits in all of this misconduct.
The expert in this case routinely, throughout the entire testimony, opined that the disorders contributed to cause the misconduct. I don't think we can find an actual causation of why somebody does something.
How did this contribution cause 5 people to spend 28 days in jail?
Well, as the expert testified, Judge Carr suffered from mistreated or untreated sleep apnea, menopause, and then a generalized mood disorder. And the issue here is that her treaters were essentially mistreating the conditions, causing there to be counteracting issues. So when it comes to sleep apnea, she was unable to get the sleep necessary. When it comes to the menopause, she was dealing with issues wherein she wasn't able to function to 100%.
How does sleep apnea or menopause contribute to lying?
Well, it affects her mood. It affects her ability to think clearly. It affected numerous areas of her life.
The justices did not seem to buy this explanation.
But if she was being treated, let me read you the first sentence of paragraph 153 of the report. She was already being treated at this point. It says, respondent misled her lawyer, her character witnesses, and her therapist to make her misconduct appear less serious than it was. Considered with respondent's lies to Judge Early and the media, and hence the public, about not issuing KPSs and her falsification of journal entries, these lies to her own lawyer and therapist demonstrated disturbing dishonesty that pervades respondent's behavior in this case. Connect, please, the sleep apnea or menopause to those actions.
Oh, yes, Your Honor, and it's the expert in this matter opined, again, that those disorders contributed to cause the misconduct. The rule calls for a qualified healthcare professional to make these opinions. And this expert was given great credibility by the panel and board. Now, he opined that the sleep apnea, hypopnea moderate, the menopause, along with the generalized anxiety disorder, contributed to cause the misconduct.
Counsel, is this the treatment provider who didn't read the record, who admitted to only glancing at the reports and the 7 hours of video?
Yes, Your Honor.
The argument seems to boil down to the credibility of Carr's expert witness, who testified that sleep apnea and menopause could play a contributing factor in causing the misconduct that was alleged. However, there were many issues with the expert's testimony, as addressed by the board's attorney.
First of all, opposing counsel stated that the board gave Dr. Reby great credibility. The reality of it is that while the board treated Dr. Reby with the respect that he deserved, they completely eviscerated his credibility based upon several factors. Number one, as this court has already stated, he was conflicted in his testimony and in the dual roles that he undertook in this case. He started out as an objective forensic psychologist who was there to give objective advice and testimony, and within a month of authoring his report, he transitioned to her treating clinician, in which he was obligated to do his client no harm. And as the chief brought up, he testified that he viewed 15 to 30 minutes of video in arriving at his conclusions. Relator provided him well in advance of 7 hours and 38 minutes of video, and there was simply no reason for him not to have viewed the entirety of those videos. And as the board noted, you simply cannot get the flavor of the volume and depth of this misconduct without viewing the video. Even that's stated directly in their report, which was 58 pages long. So that gives you an idea of the depth of the misconduct here. And then, as Justice Fisher pointed out, Dr. Reby himself admitted that he could not make a connection between his diagnoses and the lying.
Ultimately, the Ohio State Supreme Court took the case under advisement and will decide Carr's fate here in the near future. However, the board is recommending a 2-year suspension of her law license. What do you think? Is a 2-year suspension enough? Is it too much? Or is it just the right amount of punishment for this type of misconduct? Let us know in the comments below. And remember that no matter who you are, you have value and you have rights. Do not be afraid to use them, and we'll see you next time right here on Legal Dissent.